各位同事，聽唔聽到啊？係各位同事。
Members, good afternoon. This is the Bills Committee of the Employment Amendment Number 2, Bill 2017. We have attained a quorum, and it's time to start our meeting. First thing is to elect the chairman. A valid nomination has to come from a member making the nomination and seconded by another, and the nomination is only valid when accepted by the nominated member. Mr. Ho, I nominate Mr. Kwok Wai Kang to second that. Yes, and I accept the nomination. I've been nominated, so I have to ask another member who is not nominated, who is highest on the President's table, to chair the remaining part of the meeting, Dr. Fernando Cheung. All right. Do we have another nomination? No? Then I declare that Mr. Kwok Wai Kang is elected chairman of the Bills Committee. Thank you, Dr. Cheung. Members, do we need to elect a deputy chairman? No? Thank you. Let's invite the officials to join us.
我份廣告喺邊？呢個係廣告嚟㗎。OK， 但係點解咁少同事喺度嘅？好，麻煩晒。咁你
Welcome. We have Mr. Young, Ms. Alice Young Lai San, Senior Administrative Officer, and from the Department of Justice, Mr. Alan Zhong, and Ms. Queenie Wong from the Assistant Commissioner, Ms. Front Lui, as Senior Labor Officer. Over to you, Ms. Wong, for an introduction. I'm going to introduce the bill. The Labor Department is responsible for enforcing the Employment Agency's regulations, which provides that a license has to be issued by the Labor Department. And the maximum fee that an employment agency can charge a job seeker is 10% of the first month of salary. We have been cracking down on illegal charging of job seekers, overcharging of job seekers. With 3,000 EA, 1,400 of them are providing services in relation to foreign domestic helpers. Since 2014, the Labor Department have implemented different measures to step up the monitoring of employment agencies. We have increased the manpower to inspect employment agencies. In January, we also promulgate the Code of Practice. So in respect of overcharging of EA, overcharging of job seekers, especially foreign domestic by EA, that we come up with 5 measures in 5 aspects. First, we are going to impose heavier penalties for overcharging job seekers or on commissions. Once convicted, the maximum fine is $50,000. Since the public are very concerned about overcharging by EAs of FDH, and we would like to increase the penalties from the current $50,000 and to $350,000 and imprisonment of 3 years, so as to achieve a greater deterrent effect. The maximum penalty for unlicensed operation of employment agencies is the same as the first one, that is overcharging of job seekers. And now we have increased the penalty for the first. We would like to increase the maximum penalty for this offense to a maximum fine of $350,000 and imprisonment of 3 years, so as to plug the loophole. And we're also going to extend the scope of the offense of overcharging job seekers to associate, in addition to a licensee. At present, only the licensee of an EA will be liable to the overcharging offense. We'd like to extend this to related parties to an EA, including managers, which are associates such as secretary, managers, and if it's a licensed EAs, then any partner or persons involved in the management of EA will also be covered. And we also would like to extend the offense of overcharging to all these people, to all these associates, so as to ensure this sanction is effective. And we are going to provide new grounds for refusal to issue or renew or revoke a license. Since we are extending the offense, the scope of the offense to associates, we would like to provide for the commissioners to act in accordance with Part 12 of the Employment Ordinance, and also under Section 62. To refuse to issue or to revoke and refuse to renew the license to the person who are guilty of such offenses. And we have also provided the guidance, relevant guidance in the Code of Practice for employment agencies. In addition, if the person who intends to operate an EA has a conviction of an offense against a person or of a child, young person, or women, or of an offense involving membership of trial society, fraud, dishonesty, and extortion in the past 5 years, it would be he would be refused a license, or the renewal application will be denied. And also, at present, it is possible for someone who can ask another person, such as his family members, to apply for another EA while retaining control of the second EA. To plug this loophole, we propose a new ground under the new system for the commissioner to consider revoking or refusing to issue or renew a license to an EA if any related person in respect of EA have been convicted of an offense. And we're also going to provide an additional ground that if the licensee is not a fit and proper person, we would like to empower the commissioner to refuse to issue a license if the Code of Practice is violated. But there's some concern that since the Code of Practice has no legal statutory basis, so we would like to take the opportunity to provide in the EO to issue from time to time the codes of practice for EAs, and so that non-compliance with the code by the licensee and or associate would be a ground for the Commissioner for Labour to refuse to issue or to renew a license. All the amendments are aimed at providing better protection to job seekers, and we are also going to provide high standards for EAs and associates in response to the aspirations of job seekers and stakeholder parties. We have consulted the Manpower Panel and the Labour Advisory Body. We have they are generally supportive. So I would like to urge members to pass this bill expeditiously so that the public and job seekers will be properly protected. I think the Assistant Commissioner has given us a very clear and succinct introduction. So the floor is now open for members to raise questions. Mr. Poon Siu Ping, 5 minutes. Well, I support the bill, but I need to clarify a few things first. As said, there are 3,028 employment agencies. Among them, 1,416 are providing services for foreign domestic helpers. So half of them are not in this line of business. There are trade unions and training institutions which are also holding licenses of employment agencies, although they are not active. So will the bill cover these employment agencies as well? The original penalty is $50,000 in fine, and the new penalties will be $350,000 and 3 years imprisonment. And we hope that this can prevent overcharging by EAs. And 420 complaints, or 80% of the complaints lodged with you, are about 2 employment agencies. So we're talking about 1 or 2, or just 2 EAs providing the foreign domestic related services. And I have a question about associate. Are these EAs licensed as a limited company? So they have managers, and the shareholders do not have to shoulder any liability. So are you saying that under the amendment bill, the shareholders will also be held liable? What kind of coverage? How big is the coverage? First of all, this bill will cover all employment agencies, whether they are offering a service for local recruitment of employees or for recruitment of foreign domestic helpers. There are non-profit organizations which have got a certificate of exemption from the Labor Department. They also be regulated by law. For law-abiding employment agencies, the heavier penalties introduced will not affect them. For example, they should not overcharge job seekers, and the amendments will have a minimum impact on these EAs. Among the 529 complaints, 420 was the result of the collaboration with the Philippine Consulate General. 420 of them were referred to us by the consulate. One of them was convicted in 2016, and the license was subsequently revoked.
For another EA, we are undergoing legal proceedings, and hopefully they would be convicted as well. We are expanding the penalty for the overcharging of commission. It will be extended to management or members of the management, or even staff members. We hope that the offense of overcharging can have a greater deterrent effect, so that staff members who are instructed by their bosses to overcharge should report the matter to the Labor Department. By expanding the scope of the offense, we hope to achieve a greater deterrent effect. We see that foreign domestic helpers are often overcharged by the EAs. In some cases, the licensee might instruct their staff or other persons to receive the commission, but due to limitations of the current legislation, we are unable to prosecute those persons. In 2014, there was a case in which an EA in sole proprietorship, after we received a complaint, the complaint was about the EA overcharging. After investigation, we found that the staff of the licensee was the person overcharging, and we sought legal advice, and we realized there was no substantial grounds for a prosecution. That's why we are suggesting this amendment. Mr. Poon Siu Ping asked whether shareholders or partners would be included, and it depends on whether they are in the know. Even for the licensee, assuming that they are not in the know, would they be exempt of liability? We need to look at the amounts of evidence in a case to see whether prosecution can be made against a shareholder. If a person is instructed by a shareholder or licensee, and if the money ends up with the shareholder or licensee, then we might make a successful prosecution. Dr. Fernando Chang. We welcome the legislative amendments under the bill by the Labor Department. We agree with the principles. And on the overcharging of job seekers, enhanced penalties against unlicensed operation, for example, 3 years of imprisonment, etc. We also support expanding the scope of the offense to persons outside of the licensees. So you will achieve a greater deterrent effect, and you are providing a legal basis for the guidelines so that if EAs do not follow the guidelines in the future, they might be punished. In terms of, for example, refusal to renew their license, etc. Or in the Code of Practice. In the new Code of Practice published this year, there were recommendations proposed by the CTU and domestic worker trade associations, and we support them. As for the content of the bill, we support the government's amendments. Currently, a lot of intermediaries would withhold the passports of foreign helpers, and we would deal with these cases as cases of theft. In Singapore, there is legislation to penalize intermediaries who withhold the passports of foreign helpers, and they might be imprisoned. If we consider such cases as theft, we might be able to deal with part of the problem, but theft and the illegal withholding of passports are two different matters. If passports are withheld, perhaps the consent of the passport holder has been secured. For example, the intermediaries might be withholding the passports in order to complete certain procedures, but subsequently they refuse to return the passports, but they might not be any evidence to indicate that. So when we talk about theft, it's usually defined as obtaining personal belongings without the owner's consent. But for these passports, sometimes the passport holder's consent has been obtained, but in some cases they are not returned. So it's very hard to define whether consent has been obtained. So in Singapore, their laws have catered for these situations. So would the government learn from Singapore? And include the illegal withholding of foreign helpers' passports. So I expect an answer from the administration. Thank you very much. And thank you very much for supporting the bill. As for the illegal withholding of passports by EAs, according to the Code of Practice in paragraph 3.11, employment agencies cannot withhold the passports of workers. If they do, they might be committing a theft offense. If there's no reasonable ground, for example, applying visas for their helpers, withholding of passports might be seen as a contravention of the Code of Practice, and the EA's license might be revoked. Hopefully, we can strip the unscrupulous EAs of their licenses. Apart from enhancing law enforcement, we will turn to publicity initiatives. Last year, we published a do's and don'ts pamphlet to remind domestic helpers that their passports could not be withheld by the employment agencies. So hopefully we can minimize such occurrences. Ms. Andrew Wan, thank you. I support the principle of the bill, and the penalties for unlicensed operation would be raised to $300,000 and 5 years of imprisonment, and the Code of Practice is expanded, as well as the liabilities of persons rather than the licensees. But the government's answer to Dr. Fernando Chang have not been enough. When the Code of Practice was implemented and the signing of authorization letters have become a norm in the industry or trade, and people would come up with ways to circumvent your rules. So at the court, this might become a valid argument, and the foreign helpers might have signed the authorization, but whether or not they are really willing, it's a doubt. So I hope we appreciate the situation. If we do not deal with it with the law, or through, if you want to use law enforcement to deter EAs, I have some concerns. Passports are being withheld because sometimes helpers have to take out loans to pay for the intermediary fees. So this is another thing I want to ask about, the loans. After the amendment, it's impossible still to crack down on the loans. I think we are in a embarrassing situation because the connections or the interactions are very complicated, and it's hard for you to track down to the roots. If we do not learn from Singapore, then we might see no end to the problem. And the overcharging might occur in the sense that the workers would become in debt. So I support the intention, but if you are not thorough enough, people might take advantage. The withholding of passports or asking helpers to take out loans, these are things we have heard a number of times, and members raised the same concerns when the COP was being drafted. According to the COP, EAs cannot withhold the passports of FDHs. We also wrote on the COP that EAs cannot get involved in the financial matters of the foreign domestic helpers, including any loans. If EAs encourage the foreign domestic helpers to take out loans, and if there is evidence, the Director or Commissioner of Labour can revoke the license of the EA. If this is to be written in the law, as you know, we have to prove things beyond reasonable doubt. The question of producing evidence would still be here. So hopefully through the COP, we can revoke the license of unscrupulous EAs in order to achieve a deterrent effect. I'd like to follow up on that, Chairman. I hope you can make amendments, but I do not know if it's possible. If not, can you at least tell us that you will monitor the situation after the COP is enforced? I have dealt with such cases. Some helpers were forced to take out loans. So I'm very concerned about these situations. If not, can you set stricter rules? Can you promise to conduct a review a year after the COP is published in order to plug the loopholes? Thank you very much. When the COP was published, our former Permanent Secretary said that 1 or 2 years afterwards, we will review the effectiveness of the COP. If Mr. Wan has received these complaints, we suggest the helpers to report to the EA unit of the Labour Department. Dr. N. Cheng, please. Thank you. I'd like to talk about the problems faced by employers. In the past, Filipino workers have to pay a substantial sum before they can work in Hong Kong. Subsequently, we found that they had to work for 6 months or more to repay those debts. And that's why the laws were amended so that Hong Kong employers had to shoulder some of the costs, including the fees paid in the Philippines.
So nowadays, when an employer wants to employ a Filipino foreign domestic helper, he or she will have to spend almost $10,000. And the FDH is only required to pay $400. That is 10% on $4,000 odd. And many FDH would become job hoppers. They would work for 3 or 4 months and try to get another. And then the employer has to spend another $10,000 to hire a new FDH. Now we have the code of practice. Are you going to monitor the FDH, especially those who are changing jobs frequently? Has this situation been improved so far? Although this is not about this bill, but it's about money and commissions.
強嗰個對僱主保障嗰方面啦，因為我哋實務守則其實
Well, our code of practice has already provided that there should be a service agreement and an employment contract setting out the terms of employment, the day and the agreement will specify any replacement service if the FDH is found unsuitable. If we receive complaints from employers and we can prove that the EA has cheated the employer, we can revoke the license. And since 2013, the Immigration Department has stepped up monitoring. If FDH do something like that, they may be denied a visa. Yes, we want to protect FDH. They come to work in Hong Kong from a far away place, and we want to protect them. And it's also a related issue.
相關範圍問緊問題，咁而家好似印尼方面呢
It seems that Indonesian FDH are paying the fees themselves.
咁其實印尼嗰方面，其實我哋一路以嚟香港政府同埋印尼都
The Hong Kong LDCR government has been in cooperation with the Indonesian government to lessen the burden on FDH, because they may have to pay certain fees for the training, and we would like them to lower the interest charge. When the former secretary met with the minister, this issue was raised.
即係我都希望咧，就係印尼方面咧都關心下啦。我正想問埋。
So I hope we can pay attention to Indonesia. All right. So my time is up. Maybe you can wait until your second round is up. In theory, a staff member of the EA will not be so bold as to charge commissions for his own benefit. But in the past, since you could only punish the licensee, they would just blame the staff. And now the staff will also have to shoulder the liability. So this is one loophole plugged. In the past, the employer would ask the staff to take up the responsibility, to pass the responsibility to the employee. But the employee would like to continue to work for the EA. And if we keep punishing the staff, would it mean that we can never punish the real culprit? Well, we want to prevent overcharging, because the government, the general public, will find overcharging of FDH unacceptable. And if it's the employer's idea, we will ask the staff to tell us that it's the employer's idea. But we can also collect evidence to see whether it's really the licensee giving the order or it's the personal act of the staff or manager. So that we can bring the real wrongdoer to justice. When an FDH enters Hong Kong and pass through the immigration checkpoints, how much information would she get? I know you provide them with a lot of materials. In Singapore, you know, the employer and the employee and FDH has to attend a briefing session to make sure that the relevant documents are read. So if an EA commits an offense, it can have its license revoked. But this code of practice was only recently promulgated. How can we bring the attention of the 350,000 FDH to the code of practice? What publicity efforts would be carried out to inform them that apart from the regulation and the law, we have certain other matters that they need to know in the code of practice? We've asked an NGO to distribute the publicity package material so that they better understand the rights that they enjoy while working in Hong Kong. And we have also established a special web page for the FDH, and some of them are using their smartphone to access the web page. And we have also got another web page for employment agencies, for foreign domestic helpers, local employers. We provide information on not just the EAs in Hong Kong, but also the press releases and the code of practice, so that we can disseminate the information to FDH and employers. And we also set up information kiosks in Victoria Park and distribute leaflets and also we will take advantage of the briefing sessions offered by consulate generals in Hong Kong to inform new FDH about their rights. Your leaflets in several languages. What about the web page? Yes, we have also got different languages such as Tagalog. Mr. Paul Chair, most members are concerned about FDH, but this bill is not just about regulating FDH EAs. Local EAs will also be covered while we increase the penalties. There are people referring handy workers of responsible for handy jobs. It's like Uber. If you look at the definition, if you are providing labor or you are providing the recruitment service, I know the Labour Department has issued warning letters to these parties making referral and placement services on the internet, that they may have violated the regulation. So apart from increasing the penalties, do you think that the definition of EA would cover people referring the casual workers through the internet to their employers? According to the definition in the regulation, if they are offering job placement service, and if subsequently that would result in an employer-employee relationship between the job seeker and the employer, then it's an EA. We have apps or internet service, which if an employer-employee relationship is formed after making the referral and the two parties enter into such a relationship, then it's an employment agency. But if it's just about referring some jobs to some other people, then it may not. If we see someone advertising for such a services on the internet, we'll remind them that they might have to apply for a license. Or it's just an advisory, it's a warning. You are not trying to cover casual worker referral services. Well, if the casual worker will enter into a employment contract, no, it's just a contractor. Well, we would remind them if there is an employer-employee relationship, then the referral service comes under the scope of employment agency. I think the issue raised by Mr. Chair is a matter of concern. For example, if they refer casual workers to an employer, if there's an employer-employee relationship, of course, it's covered. But what if the website is not based in Hong Kong? They don't need a license, and you cannot block that website. So would it mean that they are out of reach of our regulation? Hong Kong laws can only be applied in Hong Kong. If in Hong Kong someone established some websites offering services, then they will be covered. But if it's an overseas website, we cannot reach out and enforce the law against them if the host is not in Hong Kong. And the referral is done in a virtual manner, then you can do nothing about it. We're not looking at the host of the website, but we are looking at whether the operator is based in Hong Kong. But what if the base is virtual on the internet? But they need to have a look at the physical presence. There's no need. Everything is done on the internet. Even the charge is collected over on the internet. If we receive complaints of this nature, we will try to collect evidence. Don't just speculate. Please look into this and see if anything can be done. If you can do nothing about it, please let us know so that we know what to do about them.
Anyone else for the first round? If not, second round, we have three: Dr. Fernando Chang and Dr. N. Chang and Ms. Abramchak. 5 minutes each, please. Thank you. On the illegal withholding of passports, the Labour Department said it is covered in the Code of Practice. If EAs refuse to follow the guidelines, they might be refused a new license or have their license revoked. does it mean that the Commissioner for Labour will always refuse to issue a new license or license renewal? So would the Commissioner have such discretion to do so? But if this is made part of the law, if they break the law, for example, when you carry out inspection and they breach the laws, then you would prosecute them, and there would be fines or imprisonment. So the deterrent effect is different in both cases. So I think you should legislate instead. As I just explained, illegal withholding of passport is fundamentally different from a theft. So you have been using an inappropriate piece of law to regulate or tackle such situation, and the withholding of passport might be considered a form of collateral or threat. If you deal with this, then you can crack down on the overcharging of commission. Even if you do not legislate, you should include it in the code of practice. We are talking about the code of practice for employment agencies. It has not been translated into foreign languages. Right now, it's only in Chinese and English. Please correct me if I'm wrong. I cannot see Tagalog or Bahasa versions of the code of practice. Domestic workers have to understand the code of practice and what the EAs cannot do, then the deterrent effect would be greater. And the domestic helpers can report to the government if needed. I know you have an information pack, but you should also translate the code of practice, or else the deterrent effect would be compromised. So would you consider translating the code of practice in the future? Thank you very much for the suggestions. The code of practice is in Chinese and English. The idea is that the COP is intended for the EA operators and what they need to follow. In order to educate domestic helpers on the contents of the code of practice, we will use other forms of publicity, such as pamphlets. Since the COP was published this January, apart from briefing for EA operators, we have visited consul generals, and we would consider booklets or simple pamphlets to educate domestic helpers of the requirements, and if they know the requirements, they will less likely be deprived by EAs. You held orientation talks, but you only visited the Filipino and Indonesian consulate generals. If the consulate generals do not hold such talks, you might not initiate them. And I think this is not ideal. Our foreign domestic helpers do not just come from these two countries, and in the past we relied on consulate generals to take the initiative. So should the government be more proactive? The former Secretary for Labour and Welfare, Matthew Chung, said that every foreign domestic helper would join this session. So do we have such plans? Thank you very much. This has been our goal all along, but due to manpower constraints, and we have identified consulate generals who have been more aggressive in sending workers. At the beginning, at the Philippines Consulate General, the number of participants at the talks increased substantially. We have also communicated with other consulate generals who are sending foreign workers. The Labour Department is happy to attend those talks or briefings. Sometimes at the Victoria Park, the Statute Square, we would sometimes ask our officers to explain the issue or answer questions from domestic helpers. We will continue to review our manpower deployment and see how we can reach out to more domestic helpers. We also told the consulate generals that briefings would be done on arriving workers, and we told them that we hope the training institutes can offer the information before they come. So we will continue to follow up on the consulate generals. What about the consulate generals who you have not worked with? We have information booths at the Thai Consulate General, and we are approaching other consulate generals to facilitate translations so that the information can be uploaded online. So the Labour Department has a 24-hour hotline, and at information packs we have also included the hotline. Foreign helpers can call 22711771 for help. Next, Ms. Andrew Wong. Thank you. The Labour Department said they would enhance evidence gathering. So what measures would be in place to complement the legal requirements? We have heard about enforcement difficulties or challenges in gathering evidence. Would there be new resources such as training and manpower? In terms of revoking licenses, we have a code of practice. Myself and Dr. Fernando Chung have stressed this a number of times. You said you have the COP. So would licenses be revoked immediately upon contravention, or would you have different tiers of contravention? If that's the case, it will be meaningless. If you are just issuing warnings and so on, it might not help. I'd like to know about the actual execution. Assistant Commissioner, I will try to talk about the manpower position. In recent years, we have enhanced the manpower provision, and starting from 2013, we have increased our target from 1,300 to 2,800 per year, or prosecutions per year. After the amendment, our work would be made easier. In the past, in some cases, licensees, they were not in the know, so we couldn't prosecute them. After the amendment, we will review our manpower position and if necessary, we might ask for more manpower based on the established mechanism. As for the revocation of licenses, I want to reassure members that we pay much attention to the deprivation of workers by agencies. After the amendment, we will carry out enforcement in a strict manner on overcharging. If you know of any workers being deprived, please report to the LD. In the future, well, I mean, in the past, some licensees said they were not in the know and we couldn't prosecute them. And the whistleblowers in the past often refuse to play witness. That's why we face difficulties in evidence gathering and prosecution. If they were willing to report to us, then our work will be made easier. If the code of practice is contravened for serious contraventions, for example, withholding of passports, if there's enough evidence and that such acts were not the acts of certain individuals, we would certainly act. If they are not caught red-handed, you will not revoke their licenses immediately, right? Can you tell us the details so that we know whether the penalties are harsh enough? Assistant Commissioner, will you issue any warnings or letters for serious contraventions? Well, for serious contraventions, will their licenses be revoked? Would there be such arrangements? When the COP was published, we came up with internal enforcement guidelines. We would define less serious and more serious contraventions. For less serious cases, for instance, if EAs forget to distribute info packs. Well, let me be more specific. If passports are withheld, would they be warned once before their licenses are revoked? We have to look at it case by case. Well, if their office is full of passports, in other words, if it's not an isolated incident, then it will be considered a serious breach. I think this is exactly the loophole. It's very easy to defend it. They can say that they have been authorized to do so, and they would not tell you the real reason for the withholding. Let's not talk about the number of passports detained. If the person in charge of the EA admits that they intentionally detain the passports of helpers, would their licenses be revoked? If they admit to the offense, we would revoke their licenses. If they admit that they knowingly breach our COP, they would not be tolerated. Well, you are not giving me a true answer.
Well, if everyone is honest, there's no concern. Now, honesty, there's no guarantee for honesty. I know you are just being responsible. Or if it's an extreme case, like you have said, well, everyone would know that the EA should go, and no one would argue against it. But what about a few? But because they may have withheld a field and release them, and then withhold others. So there's a lot of leeway for them. We have heard members' concerns. As I've said, we already have an enforcement, a set of enforcement guidelines. We know you want to know how strict the rules are. We're not going to connive at acts such as withholding passports. I don't want to say that if I find a certain number of passports, I'll do that, because that's not good for enforcement. If we have evidence that this is a deliberate act, we are not going to let it go lightly. Ms. Ann Jiang, in the paper, you state that sometimes the licensee may claim not to be in the know, and it may be a limited company. Can we ask that the licensee must be a natural person? But now it's a limited company. Both will be possible. Can we make it a rule that it must be a natural person? Well, they may. The employees of the EA might be hired by a limited company, so that may not be possible. But in view of the principle, we want to extend the scope of the offense to staff and managers. Well, but in that case, if it's a limited company, your amendments are not going to be effective. If you say the directors would also be held responsible, but a director can be just an ordinary person. He may be illiterate, and he may be paid to act as a director. I've heard that someone asked his 90-year-old grandmother to act as a director. The penalty can be as high as a fine of $350,000 or 3 years imprisonment. Some people may be concerned, may be worried. We know there are $2 company. A company which doesn't do much, it's just for accounting purposes, and there's no asset, and you can do nothing about such a company. You want to extend this to management of the EA, but we're talking about the act in the name, carry out in the name of a company. You also give secretary as an example. Are you talking about charter secretary or clerk or an ordinary secretary in the company? Since you cannot get hold of the senior people, you are trying to get those who are employed to do the job. These junior employees may not know the charge provided for in the agreement. So are you not targeting the wrong people? Well, if the licensee is a company, we can only prosecute the company. We cannot really bring the offender to justice. So for the manager, we're talking about the people who are hired to run the company, and the secretary is the company secretary. We would assess the evidence. Is it something done on the direction of the employer before we decide who we should prosecute. If it's, the direction came from the employer, then of course we would prosecute the employer. I'll give you back a minute. I'm not going to use your time. In the first round, I already asked a question along your line. We want to cover employers. Under the existing law, the employer knows that employees cannot be prosecuted, so the employer will always shift the blame to the employees. And now, under this bill, both the employer and the employees may be caught and prosecuted. But if many employees commit the offense under the same employer, the employer would also have a problem to deal with. I think the question is if the directors are just hired to do the job, they are not the principals. That depends on the evidence we can collect. Well, the ultimate goal is to find out who is the mastermind behind all these things. If it can be shown that it's the employer who is the real mastermind behind the scene, we will prosecute the employer. I think this is not the right focus. You want to prosecute the employer may claim that he doesn't know it. Maybe it's just the personal behavior of the employees, and that's why you want to cover the employees in the scope of offense. And overcharging is already not legal. And the employees are also not supposed to overcharge and pocket the money. So you are now saying that whether it's overcharging, charging of commission, or whatever, everyone will be caught. But you cannot resolve the problem of the employer not knowing anything under the code of practice. As a manager, as an employer, you should know what's happening with your employees. If they cannot shoulder this responsibility so that the people working for him can do things behind his back, he will not be a fit and proper licensee. That's good. The employer understands the responsibility. He must know. But now the employer is a limited company, a company, not an individual. That's why I asked you whether you should require that the licensee must be a natural person. You cannot prosecute a limited company. Well, under the law, if the licensee is a limited company, then according to Regulation 7, the company has to nominate one as the operator of the EA. So ultimately, there will be someone who is made responsible for the business of the EA. So if the licensee is a limited company, the limited company has to nominate an operator, and we can pursue the responsibility with the operator. Will the directors be also put on the blacklist if the licensee that is the company commits an offense, well, we will keep the information in our office for reference. I didn't say this clearly. I hope next time the Labor Department can say something about the kind of operation on the internet, very much akin to Uber. And if it's if the service is not about job placement but service referral, it would be okay. Can you confirm this? Well, because now under the bill you will cover the company, the employee, the management, so everyone will be caught. And I don't understand what's meant by other similar officer under the category of associate. I understand director, manager, secretary, but what about other similar officer? What are you trying to cover? It's ambiguous. Please clarify. But of course, we will have another chance when we proceed to the cross-by-cross examination. But can you elaborate here? We are talking about people with management functions. In Section 64 of the Employment Ordinance, we use the same term. We just copy this. Do you have any precedent cases where other similar officer will be confined to of employees with management responsibilities? The legal advisor has put some question to us. We would try to provide a written reply to address the questions. Second round, any other members for the second round? Now it's my turn. It's good to offer briefing or orientation briefings by the Consulate General. But do you keep track of the attendees? Would it be that every briefing session is attended by the same group of people? And they would just go because of the invitation from the Consulate General? As for the standards to be applied under the Code of Practice, when can you give us more information? What would be considered as serious breaches, what are not? Because we want to crack down on overcharging and unscrupulous EAs. So whether the Code of Practice is enforced strictly or less strange or generously is a concern to many members. Let me respond to the question about Consulates General. They would extend the invitation to different FDH to attend. I'll defer to my colleague who is in regular liaison with Consulate Generals, Ms. Lui. We offer orientation briefings regularly with Consulate Generals. In the case of the Philippine Consulate General, it's done twice a month. We'll give them a detailed briefing on the legal rights, the statutory rights under the law and under the contract.
And the information will be of interest even for workers in Hong Kong. And there would be briefings for those who have worked in Hong Kong, and they might come back with extra questions. So for both types of workers, we would organize briefings. As the Assistant Commissioner said, we have regular information booths at the Statute Square and Victoria Park, and then we will give out prizes, and the domestic helpers might encourage their friends to come as well. So for both new and existing workers, we hope that the briefings can enhance their understanding of the employment legislation and their rights. In terms of the enforcement guidelines, we will try to see whether we can help members understand our definition of serious and less serious contraventions. We might not want to share the guidelines with you because our enforcement work might be affected. Third round, Dr. Fernando Chang. Chairman, for the course educating helpers of their rights, they are only being held at consulate generals, and some people or workers might not benefit. For some foreign domestic helpers, their consulate generals might not be that proactive, and they have not held such talks or courses. And sometimes the work arrangements are not made through the EAs. And under such arrangement, the rights of domestic helpers are often seriously deprived. I do not want to name certain races or ethnicities, but we know that very often these helpers do not receive enough information, so they are receiving even less than minimum wage. And it used to happen on Indonesian helpers. So I think these talks, educating them of their rights, are very important. Under the supplementary labor scheme, such arrangement is in place for foreign helpers or for foreign workers. The government would provide information on the rights of foreign workers. But FDHs represent the biggest group of foreign helpers for us, or foreign workers for us, but no information is available. We should not rely on consulate generals. The government is obliged to do something. Even though this is not related to the legislation, it's about the rights of these domestic helpers. So the government must do something. They must right their wrongs. Thank you very much. We agree that domestic helpers should know their rights shortly after they arrive or even before they arrive, so that they won't be deprived. In recent years, the briefings at the consulate generals are the first step. We also introduce a website as well as a do's and don'ts leaflet. We will continue with our efforts. And with limited resources, we try to reach out to as many foreign helpers as possible so that they know their rights. The Labor Department did hold briefings before. Apart from consulate generals, we would conduct these on a regular basis. If we can secure more manpower, we might try to make these activities more regular, so that we can educate more helpers. This is something that's ongoing. in terms of language, can you go beyond Tagalog and Bahasa? The Labor Department secured translators, and we did ask the consulate generals to check whether our translations are correct. We are waiting for their reply, and once their feedbacks are received, we will make the information available online. This is something we have been doing. Chairman, I have some follow-up questions. We will end at 6:30. I think this is the final meeting of the legislative year. Correct. The next meeting will probably be in October. I suggest having an open hearing so that we can hear from more NGOs. All right. According to the new legislation, for convicted employment agencies, can we specify that the licensees involved cannot open new EAs, or that they cannot engage in such businesses within a specific time frame? Thank you very much. Under the law, for convictions under Part 12 of the Employment Ordinance, we can reject applications for a new company. Through this amendment, if a member of the management or staff member who have contravened Part 12 of the EO would constitute grounds against issuing of a license by the commissioner. For instance, I used to be a licensee of a company, and subsequently I became a staff member of another agency, etc. Does it cover cases in which the person is being investigated or on trial? According to the law, it applies to convictions. Next, third round, Dr. N. Chang. Chairman, if the government wants to legislate, we should play our part as well and contribute. And we have seen overcharging of commission. Sometimes the money is not in the name of commission. They might be charging certain fees on behalf of someone else and things like that. So would the amendment cover such scenarios? Can we stop people from overcharging such fees? According to the law, they cannot directly or indirectly charge fees outside of the prescribed commission. If eventually the money enters their pocket, it's not possible. They cannot charge photocopy fees and so on. If the proxy costs end up in their pockets, it would not be allowed. In the past, we did check bank transactions to see whether the money entered their accounts. So we did conduct such investigations. I think banks should be able to trace these cases. For limited companies, it might be hard to trace. For limited companies, well, right now, the limited company is the licensee, and it has all the liability, but the real beneficiary are the shareholders or someone behind it. Well, I'm siding with the employees. Well, I'm a boss. So how would you deal with this? If the employee agrees that the agency would repay fees on my behalf to agencies in the Philippines, would this be allowed? According to the COP, DEAs cannot be involved in any financial matters. And it would be against the COP. If the licensee is a limited company, well, individuals can also be licensees and limited companies can also be licensees. What's the justification? Paul, do you want to answer that? Assistant Commissioner. Under the law, we cannot mandate that a licensee must be an individual. Hong Kong is a free society. So long as they can secure business registration, they can apply for an employment agency license. Under the law, if they are a limited company, a nominated operator must be named in order, and he or she would be responsible for the operation of the EA. Chairman, just something off topic. Well, I'm very concerned about this issue because in the future, doctors can register limited companies. Well, as long as they have more than 5 persons, they can set up a limited company. So this is about the entire society. Of course, we understand that money can be very powerful. For instance, if I pay the money and you three would be the shareholders and and you can assign licensees and so on. Well, if you unless you name me, otherwise you will never catch me. But the partners and shareholders or other directors would certainly be caught. So some problems can be solved. So why don't you specify the majority shareholder? Under the laws, we specify directors. We consider that directors are crucial to the operation of a company. For shareholders, they might not be able to affect the decision of the company. So the key is to identify who is instructing the staff members to overcharge. Mr. Chair, third round. Chairman, I'd like to address what Dr. Chang said. For limited companies and partnerships or even shareholders, individuals, all of them are covered. Under Section 51 or 50(1), associates would also be covered. I think the net is already all-encompassing, so I do not see major issues. The revocation of license was mentioned. Section 53C too. I wonder whether the thinking is still quite outdated. You want to protect young persons and children, and you mentioned women. Only offense against the person of a woman would lead to failure to revoke licenses. I think an offense against a person should not be confined to women or men. Most domestic helpers might be women, but in today's world, we should be more politically correct.
Well, this piece of legislation also contained young persons and women. Or it's just improving the text. But perhaps we can ask the legal advisor. Well, it's not a question about the text. If it's an issue of offense against the person, why do you just confine it to young person, children, young person, and women? It's in the original law. Please look into this. Otherwise, you may be approached by the EOC for questions. Members, other questions? If not, so members, any objection to the proposal to arrange a public hearing? If there's no objection, we would arrange a hearing in October. So that's all for today's meeting. Thank you all for your attendance.